So today's topic will be supremacy of EU law and Brexit. Before we go to the in-depth discussion of our topic today, I'd like to remind you about how to write problem questions and then essay questions. But we can start with problem question style, which is IRAC, issue, rule, application, conclusion. It is very important that you identify all the legal issues that arises in the problem question. After identifying the legal issue, you need to say what is the applicable law, apply it to the facts of the case, and then conclude. It is very important that you do this in this order, because if you jump to conclusion and then say what is the law and then do the application, the structure will not be clear and you will lose marks. So it has to be IRAC structure in this order. Essay question style is similar, but a little bit different. Here, instead of applying it to the facts of the case, you have to refer back to the question and make an argument. So whatever the essay question is, you discuss the relevant law, and then you refer back to the question and make an argument about the essay. You have to make sure that you make arguments on both sides. Many times it will be for and against the statement given, but it could be a little bit different as well. So you have to make sure that you have arguments in the essay question, all possible arguments on both sides. Now, what is EU supremacy? The principle of supremacy, according to which EU law prevails over national law, is not expressly mentioned in the treaty provisions. Instead, it was developed in the case law. For example, Van Ghent and Loos is the key case for you to mention when you have a problem question or an essay question about supremacy. Make sure that you start with this case. In Van Ghent and Loos challenged the amount of import duty charged by the Dutch authorities in relation to a shipment. The company argued that the Dutch government was not allowed to increase the amount of duty payable in respect of trade between the member states under the Treaty of Rome. Article 30 prohibits the member states from introducing themselves any new customs duties on imports or exports or any charges having equivalent effect. Court of Justice held that Article 30 was directly effective. It was stated that the treaty is more than an agreement creating only mutual obligations between the contracting parties. Therefore, union law not only imposes obligations on individuals, but also confers on them legal rights. Hence, union was a new legal order in international law, for whose benefit the states have limited their sovereign rights, albeit within limited fields. In simple words, this means that Article 30, which says that all the custom duties on imports or exports and charges having equivalent effect are prohibited. This is directly effective, even if it's not written in the national law. It's written in EU law and it's directly effective to the member states. They cannot introduce any customs duties on imports or exports or any charges having equivalent effect, no matter what the national law is saying. This is because union was a new legal order. It's a supranational authority that has privilege over the national law. So even if the national law was saying something else, EU law had the priority. Also, Costa case should be mentioned about this principle of supremacy. The case involved an alleged conflict between a number of treaty provisions, an Italian statute nationalizing the electricity company of which the defendant, Costa, was a shareholder. Costa, who refused to pay his bill, argued that the company was in breach of EU law because it was not allowed to nationalize its electricity and change the prices under EU law. A monopolization of electricity would spark competition between member states, contrary to the union's central objective of maintaining unity. Here, Court of Justice held that according to Article 288 of the Treaty on the Functioning of the European Union, there was a transfer of powers to the Union institutions. Therefore, EU law took priority. It is reinforcing the principle that Union law has a priority over national law. Whenever there is a conflict, Union law will prevail. And it is very important what they said in this case, that the transfer of powers to Union institutions, which basically means that the local government of the member states have given some of their powers to European Union by their decision of entering this union. For an exam question on supremacy, you should state the main point that when there is a conflict between EU law and domestic law, EU law has the priority, and you need to cite the relevant authorities. Everything you say in a problem or an essay question has to be properly referenced in a scholar style, unless otherwise advised. For example, if it's an exam, sometimes the references, some issues with referencing is tolerated. So make sure that you understand what are the referencing rules. And if it's a scholar, you need to footnote the relevant authorities. Then state the facts, issues, and outcomes if relevant. Most of the times universities tell you that you shouldn't mention the facts of the case. However, if it is relevant to the argument, if you are making an argument you are applying it to the facts of the case, and you want to show that the factual circumstances of the case you're dealing with and Van Ghent or Costa or any other case are similar. So you're making an argument in relation to the facts. In that case, you could briefly mention the facts, but in other cases, normally it's the principle that you need to mention rather than the facts of the case. It is important to understand the reasoning in Costa. There were different arguments made in this case. By creating a community of unlimited duration, having its own institutions, its own personality, its own legal capacity and capacity of representation on the international plane, and more particularly real powers stemming from a limitation of sovereignty or a transfer of powers from the states to the community. The member states have limited their sovereign rights. So this is when they have expressly said in Costa that member states of the European Union have limited their sovereignty when they decided to enter this union. The integration into the laws of each member state of provisions which derive from the community and more generally the terms of the spirit of the treaty make it impossible for the states as a corollary to accord precedence to a unilateral and subsequent measure of a legal system accepted by them on a basis of reciprocity. The obligations undertaken under the treaty established the community would not be unconditional, but merely contingent if they could be called in question by subsequent legislative acts of the signatories. So this further demonstrates the importance of union law to have the priority over national law. The precedence of community law is confirmed by Article 288, whereby a regulation shall be binding and directly applicable in all member states, which basically means that even if the regulations are not passed in national legislations by national statutes, then even if they're not, Article 288 says that it will be directly applicable, which is this provision, which is subject to no reservation, would be quite meaningless if a state could unilaterally nullify its effects by means of a legislative measure, which could prevail over community law. So they are saying that the whole purpose of the union law is that it is supreme. And if by simply passing a national legislation, they could nullify the union law, then it would have no purpose. Therefore, as per Article 288, the union law is directly applicable. In case the country is in breach of union law, there is a procedure that a citizen, an EU citizen, can bring an action against the member state for failing to comply with EU law, which is called state liability. We have a tutoring session recorded about state liability that is on our YouTube channel, and you can have a look at it on our YouTube channel. Also, there is another procedure where EU itself can bring an action against the member state, which is 258 article procedure. Here we're going to discuss Simmenthal SpA case, which is also an important case about this topic, supremacy. A beef importer from France wanted to import beef into Italy. The French importer was required to pay an inspection fee, as stated by Italian domestic law. This violated the EU law of free movement of goods in the EU. Italy argued that the rule of the inspection fee, which was passed in 1970, was passed after EU law. Therefore, it had to take precedence over EU law because it was more recent legislation. The Court of Justice confirmed that EU law would take precedence. It doesn't matter. This is the doctrine called implied repeal, when the statute that is passed, the more recent statute takes precedence over the older one, but EU law is an exception to that principle. EU law is always supreme, and that's what it was argued in this case. The principle of supremacy would not exist without the doctrine of direct effect. Direct effect is a very important doctrine that you need to revise. Most of the times it comes up on EU law exams. It's usually a problem question, but it could also be, in more rare situations, it could also be an essay question. So it is important that you understand how direct effect works. Direct effect makes EU law applicable and enforceable on a national level, and the principle of supremacy ensures that national authorities are not favoring their own national law in situations where EU law is applicable. Article 267 TFEU allows the member states to interpret EU law differently. However, the main control mechanism to prevent either accidental or deliberate infringements are Article 258 and 260. Under Article 258 procedure, EU itself can bring an action against the member state for failing to comply with EU law. Direct effect. A directly applicable provision which creates rights or obligations on which individuals may rely before the national courts. Direct applicability, a provision takes effect in the legal system of the member states without the need to pass domestic legislation to enforce it. So as long as there is a new EU regulation, it is directly applicable. It doesn't have to be passed. In dually state, which requires national legislation for international law to be integrated into the national legal system, EU legislation must be ratified in national legislation in order to have precedence. And UK is a dualist state, but after Brexit, EU law should not apply unless it was agreed in the Brexit deal that some parts of the EU law would still apply. Directives are capable of having a vertical effect, direct effect, but not capable of imposing obligations on other private parties. This is actually an issue that very often comes up in problem questions in EU law exams, whether or not directives have a horizontal effect. What does horizontal and vertical effect means? So for breach of directive, an EU citizen can bring an action against a state authority. However, it is not horizontal effect. So horizontal is when an EU citizen wants to bring an action against a private person or private company, not a state authority. When it's an action against a state authority, it's a vertical effect. General rule is that directives do not have horizontal effect, but there are exceptions, and it's very important that you understand what are the exceptions of directives not having a horizontal effect. There is some doctrine called indirect effect, and there are cases that gives some routes to avoid the rule that directives do not have horizontal effect. But we have an example answer on this on the website, and I highly recommend you to go our example essays on EU law and have a look at our example essays on directives and direct effects. It's a first class answer, so it's highly recommend that you read it in detail. Other important cases that you should be reading about direct effect is von Colson and Marleasing. When you receive the slides after this session, you can have a look at these cases on our website. Recommended reading, I highly recommend you to read our notes and example essays, and it's also a good practice to have a look at our quizzes and flashcards, especially if you have an exam, to make sure that you can memorize this information easily. Now I'd like to tell you a little bit about what we do at SimpleStudying and how we can help you. We are a team of content creators, a highly 10% of law students who get high grades. So basically, we are a team of students and graduates who have gotten high grades in our exams and courseworks. And we have created simple notes, example essays, tutorial videos, quizzes, and flashcards so that you can also get high grades in the simplest way possible. If our resources are not enough on the website, we recommend you to have a look at our tutoring services. Our tutoring services help students learn correctly to get high grades, practice legal writing, and get some guidelines on exams and courseworks. We have already helped thousands of law students get high grades. As you can see on our reviews, our regular students often get a first class. If you want to be our next student to get high grades, please join SimpleStudying now. Thank you for your attention.